This presentation will discuss advanced care planning in the state of Delaware. Having a conversation about what you want to have happen at the end of your life can be nerve-wracking and scary, but having these conversations with your loved ones, your doctors, and your lawyers will let everyone know what types of medical treatments and decisions you would make for yourself. That way, if the worst happens and you cannot be consulted in your own care, your loved ones will be able to make decisions based on your wishes. Every individual has the right to accept or refuse medical or surgical treatment. This is known as autonomy. Any individual is assumed to have the ability to make a healthcare decision, and in Delaware, only a physician may determine they do not. That determination must be recorded in the patient's medical record, communicated to the patient, and if possible, communicated to the patient's healthcare surrogate. If or when a patient recovers capacity, the same steps must be taken. If a patient is determined to lack decision-making capacity, another person, called a surrogate, must be designated to make decisions on that patient's behalf. This lack of decision-making capacity may be due to unconsciousness, the patient's inability to make an informed decision, or the patient being unable to communicate that decision. Some patients, like those with Alzheimer's or other dementia, may have enough capacity to choose a surrogate to make decisions for them, but not to make their own informed consent decisions. In Part 1 of this presentation, we will discuss advanced care planning in the state of Delaware. Advanced care planning is a process of communication. It allows patients to make advanced, informed consent regarding medical interventions and allows them to approve of a treatment plan in the event that they cannot be consulted about their health care in the future. The process of communication is one that continues throughout a patient's life. Goals of care and treatment preferences will most likely change throughout a patient's lifespan, and identified surrogates for healthcare decision-making may change from parents to spouses to children. When major life events happen, our point of view changes with them. What may have made sense in your 20s might not hold true in your 50s. The 5 Ds are good check-in points to see if your goals of care have changed. If they have, it's time for a new conversation with your loved ones and friends. It may also be time to change your will. For example, if your husband died and he was your surrogate for healthcare decisions, you will need to choose someone new. If you have been recently diagnosed with a chronic disease, your standard of living may have changed. These are all good reasons to start a new conversation and let everyone know your thoughts. Quality of life changes as patients experience life and live it. Little injuries and illnesses add up, and a patient's quality of life may change. Quality of life for someone with an extreme medical condition, such as paraplegia, cystic fibrosis, or cancer, may be quite different from a young and healthy 20-year-old. That is why it is so important that a patient discusses what he or she feels is good quality of life, and what they would be willing to put up with other people. Goals of care change throughout the lifespan too, and not everyone will want the same things. In their 20s, patients often have the what if conversation. In midlife, the conversation can change to what am I willing to put up with? By the end of life, patients are usually more concerned with life-sustaining treatments and other end-of-life decisions. There are many things to think about while having an advanced care planning conversation. Has anything happened in your life that makes you want or not want any particular type of medical treatment or procedure? Is there someone you think might make a better healthcare surrogate than another? Why? What types of things would make a good day for you? Can you use this information to discuss things that might make that day better or worse? Do you have any questions regarding treatments or procedures you've seen or heard about? These conversations should take place with your loved ones, friends, and family members. You may have additional conversations with medical providers and legal experts. You may have one big conversation with many people, or several smaller conversations with specific groups. The more you talk about what you do and do not want, and your reasons for these choices, the more able others are to help you when you cannot speak for yourself. Informed consent is very important in medicine, and healthcare providers will ask for you to consent for every procedure or treatment they offer. Having an advanced care planning conversation with your healthcare provider is a way for you to inform yourself of treatments and procedures that may be in your future. You will have the time and ability to ask questions, discuss consequences to treatments that you can live with, or decide why a procedure may not be right for you. If you include your surrogate in these conversations, he or she will be able to make decisions for you based on this knowledge if you cannot be consulted. Once you have formed your goals of care and treatment wishes, document them. An advance directive is one way of documenting an advanced care planning conversation. It allows you to put in writing your goals and treatment preferences, as well as your choice for your healthcare proxy. And remember, an advance directive and your healthcare surrogate are only consulted in the event that you are unable to voice your own wishes. There are several different types of advance directive used in Delaware. The legal definition of an advance directive in Delaware is any individual instruction or power of attorney, or both. Some form of advance directive has been available for over 40 years. The document is generally made with a lawyer, but usually only involves broad, non-specific statements about treatment wishes in the event of a sudden accident or illness. It has been proven that advance directives are not very effective at directing care at the end of life. Living wills were created 40 years ago so that people could have some say in their care even if they were unconscious. Having a living will does not mean that doctors withhold treatments from a patient. Instead, they give providers a broad rule to follow. A living will generally has the statement, "In the event that I have a terrible accident and have no brain activity, I do not want to be kept alive." While this is a very important statement, it does not cover every possible situation in which a patient may find themselves. Living wills typically discuss instructions for end-of-life care, including specific situations in which a patient would choose not to prolong their life. For example, if a patient is diagnosed with an incurable condition, they may choose to decline CPR if they collapse. Living wills may also include specific instructions regarding medical treatments, like nutrition and hydration. A power of attorney is given the right to make decisions for you in the event that you cannot do so for yourself. They can make real-time, specific decisions for you based on your goals and wishes. There are two types of power of attorney. One can make financial decisions, and one can make healthcare decisions. Although you may elect to have the same person as both a financial and a healthcare power of attorney, having one does not mean you automatically have the other. If a patient loses their decision-making capacity, their power of attorney for healthcare has the authority to do certain things. They may consent, refuse, and withdraw consent to any and all types of medical care. This includes any treatments, surgeries, diagnostic or medical procedures, and medications that healthcare practitioners may suggest. They are also permitted access to the medical records and information of the person for whom they are making decisions, and may disclose that information to others. This means that, since your power of attorney is also permitted to discharge you from a healthcare institution if they feel it is in your best interest, they may disclose your records to a new institution upon admittance. Some living wills, Delaware included, allow patients to choose to give anatomical gifts in the event of death. This section is completely optional, but you may request to leave gifts to specific physicians, hospitals, or storage banks. You may also specify to which purpose you wish to leave your gift. Some options include therapy, medical education, transplantation, and research. Advance directives have come a long way in the past 40 years, but limitations still persist. Only a small group of the population has an advance directive, and they are often completed without a full understanding of what choices are being made. Many people are skeptical of advance directives and believe that medical staff will withhold treatment once they are made aware of the existence of such a form. This is untrue. Others do not discuss their goals and wishes with their healthcare proxies, family, and friends because they do not wish to have such a difficult conversation. If you do not have an advance directive or power of attorney for healthcare and suddenly become unable to make your own healthcare decisions, a surrogate will be appointed for you. Creating an advance directive and assigning a power of attorney now lets you choose who you would like to make your decisions and what those decisions should be. In order to find someone to make medical decisions for you, medical and sometimes legal professionals will begin at the top of this list, asking each person if they are willing and able to make healthcare decisions for you. The first person who accepts that responsibility will be deemed your surrogate. If you have a protection from abuse or PFA order against someone on this list, they will be disqualified. A divorce, annulment, or dissolution of marriage will revoke your ex as an agent unless you specify otherwise. Assigning a power of attorney for healthcare yourself lets you decide who you'd like making your decisions and what those decisions should be. In the event that no family members or relatives can be found, a close friend may be asked to become your surrogate. They must provide an affidavit to the medical institution or physician that they are a close friend and not a paid caregiver, willing and able to be involved in your health care, have maintained regular contact with you and are familiar with your activities, health, personal values, and morals, and can supply facts and circumstances documenting that familiarity. When making healthcare decisions for you, a surrogate's decisions must be made after consulting your physician and be in accordance with your individual instructions, goals, and values, not their own. The decision must take into account your likelihood of regaining decision-making capacity, your likelihood of death, and the treatment's burdens and benefits to you. They must also take into account any previous statements you have made to family, friends, healthcare providers, and religious leaders. In other words, their decision must be made in your best interest. Your surrogate will not be asked to make decisions for you until such time as you are unable to make them yourself. If no surrogate can be found for you for whatever reason, the Ethics Committee of the institution will be called. The committee is made up of different healthcare providers who will review your case and make a medical decision that is in your best interest. They may assign a physician or social worker not on your care team to be your guardian until such time that the Court of Chancery can be contacted. The court will then assign a guardian who will make decisions for your care that are in your best interest. In 1991, a group of people in Oregon got together to change the way we look at advance directives and end-of-life decision-making. Because advance directives have problems directing specific care at the end of life, medical and legal professionals in Oregon created a new document, the Physician Orders for Life-Sustaining Treatment, or POLST. Since then, 49 states have developed some form of POLST document. This type of form has been proven effective at aligning patient preferences with the type of care they receive at the end of life. This map represents the POLST effort as of June 2017. South Dakota is the only state without an active form. Although the forms have different names in different states, most enjoy reciprocity with their border states. As you can see, Delaware and each of its bordering states uses a POLST form for end-of-life care. The Delaware version of DMOST is called the Delaware Medical Orders for Scope of Treatment, or DMOST. The DMOST program began in 2013 when medical and legal citizens and professionals met to begin implementing a Delaware version of DMOST. The DMOST statute was signed into law on May 28, 2015, finalized on January 1, 2016. The form then went live on April 1, 2016, and can now be used by the public in conjunction with other advanced directives in the state of Delaware. Advanced directives and the DMOST form work together to provide end-of-life care, but there are differences between the two documents. An advanced directive is for anyone over the age of 18 and must be translated into specific medical orders once a patient enters a healthcare institution. The most important distinction about a DMOST form is that it is only for those patients whose medical practitioners would not be surprised if they died within the next year. The DMOST form is an end-of-life medical order. It is immediately actionable and does not need to be translated. It is honored in all medical institutions in the state of Delaware and must be filled out with a doctor. The DMOST form can also be initiated or changed by a patient's representative after the patient has lost decision-making capacity. Advanced directives and DMOST forms follow the last-in-time rule. Whichever document has been signed most recently will be the one to which medical and legal professionals will refer. It is highly recommended that you make sure that both documents match in terms of medical procedures and treatments, so there is no confusion about your goals and wishes. There are several advantages to filling out a DMOST form. It is an actionable, portable medical order. This means that, in the event you are being transported somewhere by ambulance, the paramedics are allowed to follow the orders on the form. This is not true for traditional out-of-hospital institutional forms. The DMOST form travels with you so that every healthcare institution you visit is aware of your choices and wishes. The form can be changed whenever you need it to be, and, unlike traditional advanced directives, your authorized representative may modify or initiate a DMOST for you after you have lost capacity. The DMOST authorized representative is someone you designate to make changes to your DMOST form if you lose capacity. This person should be the same person authorized to be your healthcare power of attorney in your advanced directive. If you do not have an advanced directive, your representative must be someone from the surrogacy statute, or, in some cases, may be a guardian appointed by the Court of Chancery. Designating someone as an authorized representative on a DMOST form does not overrule any healthcare power of attorney indicated in an advanced directive or a guardian appointed by the court. Your authorized representative may not make decisions for you until such time that you cannot be consulted personally. You, your authorized representative, and your healthcare provider may initiate a DMOST form if your provider would not be surprised if you died within the next year. Although the DMOST form may be initiated by any healthcare provider in the state of Delaware, such as a nurse, therapist, or social worker, only a physician, advanced practice nurse, or physician assistant may sign the DMOST form, thus making it medical orders. If you have given them prior permission to do so, your healthcare provider and authorized representative may also initiate or change your DMOST form after you have lost capacity. The following slides contain information you and your doctor should discuss while filling out a DMOST form. The front of the DMOST form contains the standardized medical orders that all healthcare institutions in the state of Delaware must follow. The first part of this form includes several things you need to know before executing a DMOST form. Most importantly, a DMOST form is completely voluntary. No institution or provider can require you to fill out the form for purposes of admission or insurance under penalty of law. You may void or change the form at any time. Other things to note in this section are: 1. If you do not complete a section of the form, the full treatment from that section is assumed. And 2. Comfort measures will always be provided regardless of the level of care you choose. Section A is the only part of the DMOST form that is not medical orders. In this section, you and your healthcare provider will discuss your goals of care. This will help your healthcare provider counsel you regarding the treatment options in the next sections, and will let your authorized representative know the reasons behind your goals. These goals can include things like not dying in a hospital, being able to walk around the mall or play a round of golf, or attend an upcoming event. They can also be specific. If your goal is to attend your grandson's birthday party in May, and then you want to die peacefully, let your provider know. They can make a note that, after the birthday party, you would like to modify your DMOST form. If you have lost capacity by that time, you may permit your authorized representative to modify the form for you. In Section B, your healthcare provider will discuss the choice between Cardiopulmonary Resuscitation, CPR, or Do Not Resuscitate, DNR. CPR is an emergency procedure used if a person's heart is not beating and they are not breathing. CPR is an emergency procedure and will most likely result in broken ribs. Healthcare providers may need to use things like mechanical ventilation, a tube in your throat breathing for you, and cardioversion, using shock paddles on your chest, to restart your heart and get you breathing again. In order for these advanced cardiac life support, or ACLS, procedures to be effective, you will need to be kept in the intensive care unit, or ICU, for medical care and observation. If you choose Do Not Resuscitate, DNR, doctors and nurses will not use any life-saving procedures if they find you without a pulse and not breathing. Your healthcare provider should discuss the risks and benefits of CPR for you based on your medical history and your goals of care. Section C discusses the medical interventions you wish to accept or refuse. If you choose full treatment, medical staff will do everything possible to keep you alive. If you elected to receive CPR in Section B, full treatment must be selected in Section C, because your healthcare team will need the option of placing you in the ICU for continuous care and monitoring. If, however, you do not wish to enter a hospital, you may elect limited treatment or comfort measures only. In this section, your healthcare provider will also discuss things like chemotherapy, dialysis, or blood transfusions. You also have the option of a limited time intervention, trying a treatment or procedure for a set period of time to see if it works. In Section D, your healthcare provider will discuss artificial nutrition and hydration with you. It is important to know that food and water will always be offered by mouth first, if possible. In this section, you should discuss your treatment options and choices regarding IVs and artificial nutrition. You may decide on a trial period for this section after discussing with your healthcare provider. In Section E, your healthcare provider will ask you for information about your authorized representative. Your representative should be made aware of all the things you and your healthcare provider discussed during the DMOST conversation. In fact, having your authorized representative there for the conversation is encouraged. In this section, you may give your authorized representative the ability to change or modify your DMOST form in the event that you lose capacity. Perhaps you want to see the birth of your youngest granddaughter, and then you want to be kept comfortable. Your authorized representative and your provider can modify your DMOST form for you after you have lost decision-making capacity, but only if you give them permission to do so. Remember, your DMOST form, like your power of attorney for healthcare and advance directive, is only used in the event that you cannot give your permission. Once you and your healthcare provider are happy with your conversation and the responses you chose, it is time to sign your DMOST form. You will sign first, followed by your physician, advanced practice nurse, or physician assistant. If a social worker, nurse, or someone else was helping you fill out the DMOST form, the person signing it should quickly go over it with you to make sure everything is correct. It is important to know that once the physician, nurse practitioner, or physician assistant signs the form, it goes into effect immediately. Any choices you made on the form will be followed from that moment on. This means that if you chose DNR, do not resuscitate, and you are found without a pulse and not breathing, no one will do CPR. Once you and your provider have filled out and signed a DMOST form, your provider will make a copy for their records. Then they will give you your original DMOST form in a pink envelope. This envelope travels with you. Whenever you go to a new medical institution, let them know you have a DMOST form, and let them make a copy for their records. Your healthcare provider will also give you a pink sticker. Place it somewhere obvious in your home. EMTs and paramedics have been trained to look for and to ask about DMOST forms and stickers. Tape it to your headboard, put it in your glass china cabinet, put it anywhere people will see. Remember, every medical or healthcare institution in Delaware must follow the directions indicated on your DMOST form, including first responders. A patient may void or change their DMOST form at any time. If your circumstances or wishes have changed, you must void your old DMOST form. You are under no obligation to make a new one, but if you choose to do so, you must have another conversation with your medical provider, where they can discuss your new goals of care with you and guide you through your treatment options. Your authorized representative may also void and make a new DMOST form on your behalf if you have given them permission to do so. Remember, your living will, DMOST form, and healthcare power of attorney are only consulted if you cannot make the decision for yourself. It is important to continue having these conversations with your family and friends so that everyone knows what you think is the most important thing in your healthcare. DelawareMost.org is the authority for DMOST in the first state. It also has information on advanced directives, frequently asked questions, and information on other resources for advanced care planning.